At page number 73, my lord. Muniamban Papama has sold the registered sale date on 16/12/2022. Page number 73, my lord.
When counsel for the petitioner submits that when an application is filed seeking to impede him in the suit as a defendant has sold away the property to the petitioner only on the ground that is pendency. The court had dismissed the application. It is submitted that the same is contrary to the settled law. Considering the same, there shall be stay of all further proceedings pursuant to so and so. The petitioner shall amend the shall carry out the necessary changes in the cause title and stating that the notice is not necessary to the respondents
3 to
so and
13.
so, but he cannot cannot say that they have to be deleted from the cause title. Yes,
And also sought for an interim order, my lord, because they,
I've already granted. Next,
Serial number
Please.
32,
Please,
Deepak
ma'am.
DC. S. Subramania.
My lords, I appeal for the petition, my lords. Filing a memo, my lords, seeking dispensation of notice to respond number 1 to 24, my lords, as they've
MO
sold
is
the
filed seeking dispensation of notice to 1 to 24, dispense with
My
it.
lords, the urgency is this, my lords. Matter is before the trial court is tomorrow, my lords. My application for
Do
treating,
that.
my lords, I had filed an application to treat my written statement as plain, my lords.
This
As-
matter came upon 24/7/2026.
Please, my
I
lords.
heard it. Because I felt it, it is not a case for interim order. I have asked you to
Please, my
take
lords,
out
we have
notices.
served on the,
So,
Please,
this
my lords.
matter will be heard finally when once the notices are served.
that is what, my lords. I am seeking dispensation, my
That's
lords.
what I
Others
have
are on
granted. Then what about 26?
My lords, it is served on the council appearing before the trial court, my lords.
Where is
Memo
that?
is also filed to that effect, my lords, on 28 July 2026.
Who appears for R30?
My lords, R30 is the plaintiff number 1, my lords. He is not contesting before the trial court, my lords. For the best
If I
reason known
notice
to
to him
my
is also
lords.
not necessary, file a memo.
Please, my lords, I'll file it right away, my lords.
Notice to R30 is also dispensed with at the risk of appellant. 29,
On 28 July, my lords, I
respondent
filed.
number 29. Short memo. To whom you have served?
My lords, on the council appearing for defendant number 26, who is respondent number 26 here, my lords.
Advocate for respondent number 1 to 25.
Here, my lords, in the first. Here, my lords. This. First one is copy received, advocate for defendant number 26, my lords.
A memo is filed stating that the notice is served on respondent number, counsel appearing for respondent number 29. A memo is filed in that regard. Accordingly, notice to respondents 29 is held sufficient. Yes.
My
Yes.
lords, an IA was filed, my lords,
Yes.
to treat my written statement as plaintiff, my lords, as I was transposed as plaintiff number 2, my lords. The only ground wherein it was dismissed was there is a direction from this honorable court to dispose of the matter as expeditiously as possible, my lords.
Where is that order?
My lords, order is at annexure A, my lords, page number 26, my lords. May I read, my lords? That is the only ground taken, my lords. And objections is filed only by defendant number 25, my
What
lords.
is that application?
To treat my written statement as plaintiff, my lords, as I've been transposed as plaintiff number 2 in the case, my lords.
Yes.
I am for the defendant number 25, my lords. My lords, in this case, plaint already presented by the original plaintiff, my lords. There cannot be two plaint in the one suit, my lords. That's why we object it, my lords. In the, we file, defendant number 25 filed the objection also, my lords. In this regard, the honorable court reject their application. Then after, if they lead the evidence as a witness only, my lords, and there cannot be a two plaintiff in the one suit, my lords.
My
Day
lords,
after
I've
tomorrow,
been,
heard reserved. Yes, next.
Cell
For
number
judgment day
33
after tomorrow. Next.
33 is
ಇದ್ರಲ್ಲಿ
33
ಹಾಕಿ.
disport 34 Manjunath HR.
That
Cell
was
number
held for
34.
some time, my lord. It was directed to place judgment of the trial court on record, my lord. Filing the judgment of the trial court, my lord. Wherein the JDR number 1 in the execution petition, she is having 1/8 share, my lord. She has executed a will in favor of the son-in-law, my lord. And I filed an application upon her demise, my lord. I filed an application to bring me on record as a legal representative of the deceased JDR.
So is this the case where you have no right to execute the,
Yes, my lord. So far as item 1 is concerned, my lord, it's a father's property, my lord. She has not, absolutely, she is not having the right. That is not the subject matter of the execution petition, my lord. The Bangalore property is the item number 2, for which she has acquired the property on her own, in her own name, and she has bequeathed the property in favor of her son-in-law, my lord.
well, if it is her property, it wouldn't have been in the partition suit.
Yes, but that is also included, my lord. The merely because Hiba has not been proved by the donees in the that particular suit, that suit came to be decreed.
What is the finding in the suit with regard to this? If in the suit,
Please.
any property fell to the share of this person
Please.
who has executed a will in your favor,
Please.
that's a different aspect.
That is why-
If-
that's-
If it is not fell to her share, her rights are not determined, question of impleading you in the execution proceeding does not arise.
My lord, she is having 1/8 share, my lord. As per the judgment passed by this with the trial court, my lord, she is having 1/8 share, my lord. To the extent of 1/8 share, I can come as a legal representative of the deceased person to claim her 1/8 share by virtue of the registered will executed by her. That is my humble submission.
She has executed a will in respect of a particular property. How will you be entitled for other properties?
No, my lord, this particular property is a subject matter of the will, my lord. And after being contested in the suit, she is entitled, she has been declared as she is entitled to 1/8 share of the property, my lord. Since she has left behind a will,
Where is that? Where do you get that?
my lord, in page number 12 of the judgment,
Oh.
along with the memo, I produced the judgment copy.
Hmm.
The suit of the plaintiff is decreed. Plaintiff 1 and 2 are entitled to 1/6 share each in the social properties. Defendant number 1 is entitled to 1/8 share in the social properties.
12?
1/8 share. Defendant number 1 is.
What is the name of who has executed the will in your favor?
Sharfanisa is a,
Huh?
Sharfanisa, her name is Sharfanisa. He is the defendant number 1, who is the JDR number 1 in the execution case.
Defendant number 1.
Please, ma'am.
Sharfunisa.
Please.
What are the suit schedule properties?
Suit properties are,
All the piece and parcel property, Mangalore Tile House, so and so,
please.
Ramnagara.
Ramnagara is the item number 1, my lord. That is, she has no right.
All the piece and parcel of the property,
Bearing number 11, old number.
Bangalore,
Bangalore.
measuring.
That is,
This
the-
property she has bequeathed in your favor.
Please. This property she has bequeathed, she has purchased in her own name. And however, in the suit, she is declared that she is entitled to
You know,
1/8.
that property is a joint family property. I
Uh,
mean, whatever it is, as per this suit,
Yes.
all of them are entitled for the share in
Please.
both the properties.
She is entitled to 1/8 share, my lord.
Hmm.
In execution proceedings, my lord, since she has left behind a will, I being the legatee under the will. So I have filed an application to bring me as a
But
legal.
then, against this, an appeal is filed.
Appeal is filed, madam. In the appeal,
What is the judgment in the appeal? Come to the appeal.
appeal has been dismissed, my lord. Appeal filed by the daughters
Hmm.
came to be dismissed, my lord.
Come to that.
Page number 25, my lord. Wherein the honorable high court, this honorable court has held that the trial court has, the parties have not proved the due execution of Hiba.
No, no. Where is the appeal judgment?
I filed along with you. Ma'am. Last occasion I filed.
This is a suit one.
Suit, last occasion I filed along with memo.
You have a copy?
Please.
Please give it. Please come. When counsel to the petitioner submits that the defendant number one in the suit has executed a gift deed in favor of, as bequeathed of property by way of a will in favor of the petitioner, and she was granted 1/8 share in the suit scheduled properties. And that property is a suit item number 2 of the suit scheduled properties. When the petitioner has filed an application to impede himself in the execution proceedings that came to be dismissed. When he has filed an application to come on record as legal representative of the deceased JDR number 1, that came to be dismissed. When counsel submits that as she has bequeathed the property in his favor, if not the entire property, whatever is the share, he would be entitled for the same in the light of the will executed, and all these aspects were not considered with the court. Considering the same, they shall be stay of all further proceedings. Notice stands alone.
Cell number 35, Angad Kamath.
Therefore, tomorrow is the case.
It will be uploaded, no hand delivery. Yes.
Cell number 35, Angad Kamath.
But commercial suit of the year 2018. No written statement filed within 120 days. Defendant forfeits both 1 and 2. It's been 8 years still pending. Under the Act, there are timelines, and if all the timelines are added, it requires 463 days to
You have
decide.
filed an application on 23/7/2026.
I have not filed. Defendant. So when it is posted for final arguments, every time it goes for final arguments, the defendant will file some or the other.
Your direction is to dispose of that
No,
application.
before that, my first prayer, if your lordship see,
I'm looking at first prayer. A.
to dispose of COM OS together with all pending within an outer limit of 3 months. The second is that no adjournment shall be granted. Even the trial judge is telling us, please get a direction, otherwise I'll not be able to complete it.
Why? Why are they telling like that? Why should the High Court tell them to do
Conduct,
their work?
the conduct, I know, my lord, your lordship generally does not like to control the board of the trial judge. Not the exceptional cases I have to make out. This is a commercial suit, one of 2018, where there is only one plaintiff witness that is produced. Defendant cannot lead evidence. Once he has forfeited his right to file a written statement, Supreme Court is very clear, you can't lead evidence positive. You can only cross-examine to show plaintiff does not have a prima facie case. One or the application only to delay. This has gone on for 8 years. And ultimately every date some or the other application is filed, some order come here. This is what is going on.
No 2008 suits are pending there on that file of that court.
Your lordship may, like your lordship does it generally, Lord, your lordship may obtain a view from the court itself. The court will only tell your lordship that in 2 weeks I'll decide this if I get a direction.
No. Why this court has to say is like no other matters are pending in that court of 2018?
No, this is the only one. This is the only one. That court has a track record of deciding commercial suits contested in 6 months to 8 months. I have gone through the judgments of that court. That particular judge, presiding officer, came then.
Calls for the petitioner submit that this is the only case of 2008 which is pending on the file of the court. and filed this application seeking expeditious disposal of the,
Petition.
the OS,
ComOS.
it's you want this, or your commercial suit itself to be disposed of.
Yes, ma'am, commercial.
The
It's already in final
Minister
argument.
Judicial is directed to call for a report from the concern. Yes,
Thursday,
Mrs. Matter on Thursday
I'm grateful.
in this one.
Cell number 36. Cell number 36, Chaudhary HR.
In an execution,
What are these non-complaints of office objection?
Milords, the office objection are that myself and my wife were judgment debtors. Arrest warrant is issued against me. I did not make my wife a party. Second office objection is, Milords, they have filed an application for issuing of arrest warrant. On that, an inquiry was conducted and then this order is passed. So whether it is an order on IA or inquiry, I have said it as an order on IA. My grievance is that, Milords, the execution proceedings.
Your wife is not a necessary party.
She is not necessary party because she can join me in that. There is no warrant against her. It's only against me. That's why, Milord, she is not a necessary party. We have not made her a party. If it,
Oh, she must have shown us JDR 1 and JDR 2.
yes, she is JDR too.
So whether you're seeking a relief to against her or in favor of
I am
her.
not seeking anything against her.
But she necessary. You should mention her, mention in the cause title, at least. That's what is the cause title of the execution case. You show her as a JDR, the notice to her is not necessary in this case. That's what will be the office note.
Yes.
These are all civil proceedings, just like the two, against whomsoever we want to make a party, not a party, that's not the way it goes.
I can make a part,
Yes.
her a party.
Office
Milords.
objection shall be complied with.
But in the
within a-
meanwhile, Milords, I can make it right now. Milords, Lordship, kindly see, arrest warrant is it's a loan. Decree was a secured property.
These are very simple if you do. Without this, it would have come in the list. You are only complicating it. Yes.
Yes, not there is execution proceedings at Annexure A, my lords, is again is a decree against a loan. It's a secured property. They have also filed an application for attachment of that property. Instead of attaching, I have said I have no objection to that. Instead of attaching the property and I have said that I have no other means to pay. It's a huge money of around 50-60 lakhs now. That you can recover the money from that is what I have even said. Instead of
If
execution,
you have said that, that means they can't attach that property.
they can attach. Let them go and attach the property. Instead of that, why are they arresting me, my lords?
Let's see that.
Yes, my lords. Your Lordship, kindly see. Annexure A is the execution petition, lords. Page 18 it starts. In page 19, your Lordship will see the scheduled property as well as.
Mortgage its property in favor of the bank.
Yes, the very same bank. They admit that entire papers are with the bank only. They can very well sell that property and recover the money.
Hmm.
And you Lordship may kindly see, Annexure C is at page 22 is an application to attach the same property in the execution proceedings filed by them. And in the affidavit, they do concede that this property is a
On
secure.
the other hand, the decree holder stated that after mortgaging the property, the judgment number 1, with an intention to defraud the decree holder, has alienated the said property to third party.
No, we have not. There is no piece of paper. There is no piece of paper for that. Even they have not said so. I have even in the cross-examination of produced, Your Lordship may kindly see page 57. I have elicited from their mouth that entire property is documents are with them. There is no objection, no problem in selling that. Everything is said. Merely because my wife happens to be an ex-corporator, and they have said that I have some rental income, and they are saying that I am avoiding to pay the money. I don't have that much money, and I have said I have no objection for it. There is no finding, no evidence to come to such conclusion that I have done anything. I'm making a statement before this honorable court. There is nothing of that sort.
Have you sold the property or not?
No, I have not sold the property. That property is very much available and it is a mortgaged property. Where is the question of me selling it? If at all they have produced an EC, it doesn't reflect any such things.
No, initially that was. Later that is brought to the notice of the court.
I can undertake before Lordship that I have not done that. That observation has come from nowhere. Hence, my lords, issuing arrest warrant, my lords, with great respect, may not be proper, is what my limited.
What is the decretal amount?
My lords, it is around 50 lakhs. Lordship will get it 58 lakh 66,229 rupees as on that day. And 12% interest on the original loan of 36 lakh is the amount. So I have said that it may be even in my objections and even in the written argument, I have said that the only property available, you may dispose it of, auction it. That's what I have been saying. Nowhere they have said that.
Then also the petitioner submits that. The court, without any basis, without any inquiry, has issued a arrest warrant. It is submitted that the petitioner is having only one property and he has not sold the property. It is submitted that the petition is ready to file an affidavit before the court that he has not sold any the property after the property is mortgaged to the bank. Further, the said observation by the court in the order is without any basis. And he has no objection for the bank to sell the said property. Considering the submission of the land counsel to the petitioner, there should be stay of all further proceedings, motion to the authority to send the notice and summons. The office objection shall be complied with within a week, or else the stay granted by this court stands vacated.
Notice to second respondent may be dispensed with, my lords. I will add, if court permits, I will add her a second respondent right now.
A memo is filed seeking dispensation of notice to the second respondent. Give the file. The petition is permitted to add the second respondent. Yes.
Cell number 37, Narendra S. 37,
Do
Narendra
that.
S.
No representation on behalf of the petitioner. Does this matter in the month of October?
Cell number 38, VG.
Where is that report?
Represent the petitioner.
Same. Plaintiff questioned the orders before your lordship by way of a writ petition. Your lordship is directed to dispose of file number 1 within 1 week. I passed the orders. After passing of the orders, once again read the order of your lordship. Then I realized what mistake I committed. It is not intentional one. I will not commit the same mistake in future.
Lords may send me back my lords, I'll take my chance again. Lords.
The present writ petition is filed. Where is the order?
Page number 22 it starts, my lords. The operative portion is at 30, my lords. The lord's earlier order is
An order. The petitioner has earlier come before this court
63, my lords.
that the present writ petition is filed questioning the order dated so and so. Earlier, the petitioner has come up before this court questioning the order of the court where suit summons were issued. Then this court has directed the court to consider the application within 1 week, notwithstanding the fact that the notices are not served on the defendants. Now, after that, the present order came to be passed. In this also, the court has not granted injunction. Simply said, call, without giving notice, this case cannot be heard and issue notice. In spite of an order passed by this court to decide the application, when this order is passed, this court has called for a report. A report is placed before the court stating that by mistake, by oversight, such an order is passed. Considering the letter received, the report from the learned judge, this court deems it appropriate to pass following order. The order dated so and so is set aside, and strictly the court shall consider the application for injunction in accordance with law within the period of 1 week from the date of receipt of the copy of the order.
Great.
Cell number 39.
My lords, the office objection is, my lords, there are 3 applications and hence 3 writ petition has to be filed. But however, it is a common order.
What
It's
are
a
those
common-
three?
My lords, IA number 16, 17 and 18 are reopening, my lords, the recalling and permit me to examine
With
one
regard to
witness.
the maintainability, with regard to the office objection is overruled. Yes,
My lords, the case is regarding, my lords, the declaration of my easementary right. My lords, this court, my lords, the earlier I had approached this honorable court. In fact, it is the other side. They approached this honorable court for vacation of the interim order. This court has, my lords, in MFA number at page number, my lords, 44, directed the trial court to dispose of the matter within 6 months. However, the matter could not be disposed of within the time. Hence, the court has requested for further time. 3 months' time, additional time was granted. Well, now every evidence of the respective parties are over. The matter was posted for the argument. I only requested the trial court to kindly permit me to examine the witness to the agreement. I will not take more than 15 minutes. So any day fixed by this court, I will complete my examination and straight away I will go for, my lords, the arguments. Now, the
This is
trial
not
court
the- This is not the case, my lord. Matter reached finality. He is appearing for plaintiff, the suit for declaration. Yeah, there is no pleading regarding this agreement. This is not the specific performance suit. This is on seeking a declaration that there is a pathway on my property. And he purchased the property during 2003 and 4. The agreement is claiming that 1996
it
agreement.
is impugned order.
And your lordship kindly see the what is the affidavit filed in
Page number?
62, my lords. Page number 62, annexure F, my lords.
Suit is of the year.
My lords, the suit is of the year
24, my lord. Since this honorable court directed him to finish the case as early as possibly within a framework of 6 months, I am entered into joint development.
Okay, it's a 2024 suit.
Pardon?
2024 suit, what will happen?
My lord, I invested nearly more than 80 lakhs for construction and entered into for joint development agreement. And
Fix a date. It doesn't matter. It's not a old suit. I can understand. If it is
no,
a
my
old
lord,
suit.
they have taken interim order and that court observed that.
I'll fix a date. On the day he should complete. That's it.
No, your lordship kindly see, without pleading, whether this witness is required, that is also question. What the affidavit, your lordship kindly see page number.
The reason for the court to dismiss it?
Pardon?
Is it the ground? Court only said the opportunity given by the court not properly
Sufficient already
utilized.
opportunity is given.
That's what. Please come.
My lord, is the 16th or 17th IAS
When
filed.
is it coming?
Huh?
When is it coming? I'll
This is-
say that no further time shall be granted. On that day, he will complete everything.
lords,
When
the
is the
matter
matter
is
coming?
20th, my lords. Day after
30th.
tomorrow.
20th, he shall complete everything. No further
Please.
time to be granted. The agreed with the orders passed on I number.
No, he is seeking witness summons. It will drag once again.
To whom?
His 1996 the witness who has signed as a witness to an agreement, old agreement. So sale deed already there 2004. Not the party's
To
witness.
reopen the side of the plaintiffs.
Opening and seeking witness summons.
CPC to recall the order. To furnish the list of witnesses. Who are the list witnesses?
My lords, only one witness, my lords, one Mr. S.D.
Let
Mahadeva,
him
your lords,
undertake, let him undertake that he will bring the witness.
Yes.
Then, if
page
that's the
number
case.
57.
When will that witness come?
My lords, I will, whenever the date fixed by this court, my lords, I will secure his presence, my lords.
Let him secure.
So what is the date?
20th.
20th.
Let him.
Yes, Mr. Counsel for the petitioner.
My lords, 20th is the date, my lords. Kindly give me 2 days, additional 2 days time. I will secure him, my lords.
Yes, 22nd. The petitioner, the petitioner, plaintiff is before this court. Agreed with orders passed on I number 16 to 18 in OS number 2966 of 2024 dated 22nd July 2026, whereby the court had dismissed an application for reopen recall and to furnish a list of witnesses. The plaintiff has filed a suit
My lords, easement
seeking a
right is
declaration that
Page number 33.
Schedule B property is easement of necessity and permanent injunction. Now the present applications are filed seeking to reopen the case that came to be dismissed by the trial court. The trial court has relied on several judgment of the apex court and observes that the opportunity given by the court to the plaintiff not properly utilized. The order sheet reveals that the plaintiffs are indulged in dilatory tactics. The legal maxim, law helps the vigilant, not those who sleep over their rights, emphasizes that the law assists those who are proactive in protecting their rights, not those who are negligent or inactive, and accordingly dismissed. Then counsel the petitioner submits that there is no intention on the part of the petitioner to delay the proceedings. It is submitted the suit is of the year 2024, and the petitioner, if one date is fixed, the petitioner will examine the witness and will complete everything in one day, and he will not seek for further adjournments. Then counsel for the respondent submits that as enough time is granted and as the same was not utilized and filing one application after the other, the court has passed the order and there is no pass the order and no interference is called for. With the well-considered order passed by the court. Next paragraph. Having heard the counsel for the petitioner, there is a material on record. The suit is of the year 2024. Now, by filing an affidavit stating reasons for the recall, reopen, and for furnishing the list of witness, the petitioner has given a reason. The order impugned, except the court referring to various judgments of the apex court, has failed to refer to the case of the petitioner. In those circumstances and balancing the interest of both the parties, this court is passing the following order. The order impugned so-and-so is set aside and consequently IA number so-and-so are allowed. Number 2, on 20th, the petitioner shall appear before the on 22nd.
22nd.
On 22nd, the petitioner shall examine the witness whomsoever is intending to examine, and after 22nd, no further time shall be given. 3, the petitioner, the plaintiff shall cooperate, shall proceed with the matter, and as per the timeline fixed by the court, this court in MFA shall be, and accordingly, as per the timeline, shall proceed with the matter. If the plaintiff fails to proceed with the matter as per the timeline, the court is at liberty to pass appropriate orders.
Cell number 40, Puneet C for petitioner.
Lord, your lordship's directions at page 235, annexure N. Earlier writ was filed before your lordships My lord, that was the writ challenging the, my lord, order of issuance of emergent notice is concerned. Your lordship on 3rd June of 2026, page 235, my lord issued certain directions. My lord, page 239. Your lordship may kindly for a moment kindly see the order of this court. My lord, page 239. Your lordship directed to dispose of, directing the trial court to consider the IN number 2 filed by the petitioner expeditiously. And therefore, please, my lord, the second observation, trial court shall pass order considering the submission of the parties in accordance with law. Now, your lordship may kindly peruse, my lord, the impugned order at page
Oh, they are questioning the maintainability of the writ petition.
20, my lord. That is what, please, my lord. Admittedly, my lord, by virtue of the impugned order, my lord, I have to go to the appellate court under order 43 rule 1R. But kindly for a moment, kindly appreciate and see the impugned order, my lord. The trial court says that this honorable court has directed to dispose of the application itself with or without notice. Your lordship directed only to consider. Your lordship never said, please, my lord, to dispose of the application itself with or
No, if
without
it
notice.
has to appellate court will not understand.
My lord, 227, my lord, your lordship's, my lord, has jurisdiction, my lord, to keep the, my lord, trial courts within their jurisdiction. That is what, please, my lord, one judgment I have, my lord.
No
which I would-
judgments, sir. We are already burdened with judgments. Don't
2000,
want
my lord,
judgments for on
2000.
every
But for a
aspect.
moment, please, my lord, your lordship's direction was to only to consider, my lord. It is my humble submission, your lordship's direction was only to consider and pass an order on as against emergent notice. The trial court sees, my lord, kindly see the impugned order at page.
No, why are you burdening the court with this kind of orders which are appealable?
My lord, though it is appealable, please, my lord.
Court will take care of it. I'll not consider all that.
My lord, in similar circumstances also in another different case, my lord, the trial court is passing the very same order. Your lordship never directed to dispose of the IN number 2 with or without notice. This is also another matter of the very same presiding officer, my lord, with all due respect. Your lordship may kindly peruse, my lord, the observation at page 28, para 3. Impugned order, page 3, 28. Page 28, my lord, para 3. May I read, please, my lord? Against the order, plaintiffs have preferred writ petition before the Honorable High Court of Karnataka, so and so, wherein the Honorable High Court of Karnataka was pleased to direct to dispose the application with or without notice to the other side. My lord, your lordship's direction said, my lord, annexure N.
So what is the prejudice to you by this?
My lord, my application is dismissed outright. My application is dismissed outright.
What is outright?
My lord, my application for injunction, my lord, earlier I filed an application, my lord.
Court said notwithstanding the fact that no notice is served on the defendant.
Your lordship only directed to consider, my lord. At the most, if I have not made the prima facie case, please, my lord, emergent notice has to be issued, and my lord, the defendants would have filed the return statement.
What is the order I am passing is notwithstanding the fact that the notice is not served, you pass orders on the merits of the
Consider, consider and IN. My lord, your lordship, kindly, my lord, page 239.
So now not granting injunction is also a problem now.
My lord, what? My lord, your lordship's direction was to
The court, if the court said whatever it is, but it granted
your
injunction to
lordship's
you.
direction, my lord, the trial court shall pass order.
Ultimately, what did the court say? It has dismissed your IA. So
Please.
what? What is
My
wrong
lord,
with it?
My lord, it's a fresh suit, please, my lord, where I sought for an ex parte temporary injunction. My lord, if I had not made out the prima facie case, please, my lord, certainly, please, my lord, emergent notice will be issued.
No. That is not, that is what they shouldn't do. That's what this court said. It understood, you have not understood.
My lord, page 239, your lordship.
And the judgment which is relied on by, referred in the judgment is that.
Your lordship's direction was to consider only, my lord, is what my submission. My lord, may I seek only this way, please, my lord, may I seek, my lord? I'll file an appeal before the.
Yes. The office objection with regard to the maintainability is upheld.
My lord, limitation is concerned.
The petitioner shall file the appropriate application within 2 weeks from the date of receipt of the copy of the
Please.
registry shall return all the documents. Yes.
Number 41. K.P. Nanjeesh Koda, hearing on interlocutory applications. First,
Corresponding in this petition.
Yes.
The suit partition,
1200 days delay.
1,200 days. If my lord were to ask me, we have explained saying that there is very not well.
Why the delay? Where did you explain? Where is that IA?
Page 91. 91. Affidavit is at 92, 93. The 70-year-old
Watson. He says that he is not well. He had to go to the advocate's office couple of times. There is no counter objections filed by my learned friend.
Lords, we'll file an objection to this, my lords. We'll file an objection to this.
We allowed him.
When did you file wakalat?
It's NOC. Yes, we have filed an NOC wakalat, but the date, I'll seek.
Filed it long back.
6th Jan.
File 11/25.
I filed an NOC wakalat on 6/1, my lords.
No affidavit at all. This can't be an affidavit on for a condemnation of delay of 1200 days. That means how many years?
3 years.
Hmm?
3 years. 3 years.
By this time, what happened to the suit?
Suit is still pending. Suit is
No,
still
it must be pending till what is the stage now?
evidence. They have to lead evidence. Evidence. Nobody has led evidence.
File an objection, my lords. Date may be given.
Who stopped you from January?
Lords.
You filed an objection in the month of January.
Yes, my lords.
We are in August. August is 8 months.
Yes, my lords.
I number 1 of 25 is filed to condone the delay of 1200 days in filing the revision. It is stated that the petition is not keeping good health. In that of the matter, the delay has occurred. Considering the no objections or filed the respondents, considering the reasons stated, the delay of so and so is condoned. Is argued on the merits of the matter.
Suit for partition. Only there is one Chikka Kempayam. Chikka Kempaya has 2 wives. The first wife is Muniamma. Second wife is Ammayamma. Now the fight is by the family members of Ammayamma. Ammayamma is the first defendant. The daughter has filed this case. Kindly see the plaintiff. I just want to say there is a clear admission that there is a partition. It is also acted upon. Ink page 31, para 4, line 4. Therefore, the second suit is not maintainable. There is no cause of action is my contention before the court.
Today, whatever the matters that are adjourned, all the matters in the first listing. We first listing adjourned matters. Any date, what is happening is that this date second, they're coming in the second list. That becomes the problem. But not coming like that. They're not coming like that. Can instruct that all matters should be adjourned to tomorrow. Come in the bus. Yes, every day.
May I read? Page 31, para 4, line 3.
Para 4.
Para 4, line 3. This is to bring home the point that there is a clear admission by the plaintiff that there is a partition that is affected in the family. Also intended to put an end to the joint family status and nucleus. Therefore, under an oral partition between Sri Chikkempaya on the one hand, first wife Muniamma and her children on the other, properties were partitioned. In the said partition, several items of properties were allotted to the share of the Muniamma and her 5 children, which they have voluntarily acted upon. Therefore, as there are no other further claim as against the items of properties allotted to the share of Chikkempaya, as such, 5 children of the first wife Muniamma were not made parties to this particular suit. 3 important dates are relevant. 1989, this Chikkempaya passes away.
1989.
And plaintiff was married prior to 1994. Karnataka Act 23/94. It came into effect in 1994. So therefore, a female in the family was not entitled for any rights in the co-parcenary property. According to them only, when the father was alive, there is already a partition that is effected.
No, who is she?
She is the
Plaintiff
daughter
is the-
of the first defendant, who is the second wife of Kempathimma. Chikkathimma. Chikka
She is
Kempai.
the daughter of the second wife,
Second wife.
through the second wife.
Through the second wife. Second wife is the first defendant before the court. She is the second. So there is an assertion that there is a partition that is affected. She is married prior to 1994. Therefore, she will not be entitled. Like in Hyderabad, we followed Hyderabad and we also had this amendment. Only thereafter 6A and Vinita Sharma, everything came. My lords are aware. So therefore, she will not be entitled. So therefore, the cause of action is not there.
When she was born,
She was born,
the plaintiff,
52 years is shown to 2014. 2014. 52 years even as in the date of institution of the suit. So obviously about 30 years backwards, even if we take, it was prior to amendment only. So therefore, this is the point that the judges have not seen. I am not harping or relying upon my written statement at all, which I can't. And Order 7, Rule 11. I can't even take my lord to any of these averments. But the averments of the plaint itself would indicate that there is no cause of action. That's all
Date
is
may
my
be
case.
given, Manoj. We'll have it in next week, Manoj. Senior will argue on the matter.
what do you think that what is happening?
Manoj.
He was arguing, he
I-
was just,
Manoj,
as if that
I-
we are going ahead with the argument when counsel for the petition submits that there was an earlier partition and the plaintiff was not entitled for partition, which is evident from the intervoments, which was not considered with the trial court. Considering the same, there shall be stay of all further proceedings. And so and so. Stay is already granted earlier.
No stage.
Stay of all further proceedings. This is matter in the month of September.
Great.
Cell number 42. See the amendment change.
Amendment paid.
What amendment?
A certain paragraphs I want to add. Maybe. The terms and conditions and the rent agreement has to incorporate. I1.
Where is this amendment here? You want to amend the petition in the CRP?
Oh,
Huh?
some. Yeah, virtually it is an ex parte order. Malad.
Notice to the respondents.
And I sought for the stay, Malad. Malad. Otherwise, the execution is filed, Malad.
What is the amount to be paid?
Malad, after filing the wakalat, Malad, the advocate for the petitioner is remained
Now
absent,
that it
Malad.
is decreed, or any amounts to be paid.
Malad, the entire amount is already paid, Malad. Advance amount after deducting the arrears of rent.
For notice, will hear them and pass orders. Notice to the respondents and summons. Yes, 43.
43. Moinuddin N for petitioner.
Okay. I'm challenging Annexure A and B. Annexure A and B. Annexure A, miscellaneous petition arising out of the Annexure B. The case of the factual matters of the case is that there was a sale deed between the parties. As per their allegation,
Where is the impugned order?
please. Page number 44.
An application under order 9, rule 9 is allowed.
Yes, sir. This is arising out of the main suit, Your Honor, original suit. You know, the original suit has been filed beyond the limitation. My one submission. We already paid the entire amount as per the sale deed, Your Honor. Their allegation is in respect. They have filed a declaration and cancellation of the sale deed.
You have to only argue on how this is bad.
Please, Your Honor.
So that's why, please, what are the reasonings given by the court and how it is wrong?
No, no,
It's
Your Honor.
hardly 2 pages order. Come to that order.
No, no, Your Honor, Your Honor, it's kindly see, Your Honor, the entire order did not include my objection and did not include my submission. Because, Your Honor,
That I can only see if you read.
that is
I
not.
can only see if you read the order. Please read the order.
No, no, the cross examination which I conducted, which is not included in my this.
Read.
Your Honor, the entire orders, Your Honor, my cross examination did not indicate so. That is the reason I am before the Honorable Court, because, Your Honor, the already suit has been restored. That suit has been filed beyond the limitation after the 3 years. At page number 8, Your Honor, of the impugned order, it is mentioned that petitioner was suffering from ill health. That is a response number 1. But there is no such material was placed before the Honorable Court, Your Honor.
Notice to the respondents, petition submitted, take out hand summons. We shall file a memo to that effect. Yes.
You know, 25th, the matter has been set down for evidence, the original suit, Your Honor. Because the suit itself is filed beyond the limitation.
If it is filed beyond the limitation, that ex parte order will not be satisfied.
No, no, my
If it is filed beyond limitation, that would be on the merits of the matter. How can you club both?
No, this miscellaneous arising out of the original suit itself. Now it's pending before the Honorable.
Will we decide about the original suit, whether original suit is within jurisdiction, within limitation or not? In a miscellaneous.
It's clearly in their pleading. It's
considered. You have to understand what can be considered and what cannot be considered in a miscellaneous. Original suit, whether it is correct or whether it is filed within limitation or not, will be decided in a miscellaneous petition.
No, my only submission is that, Your Honor, as per the allegation, we have not paid anything, but we have paid.
Yes, notice.
But we have to
44.
kindly stay the implement proceedings in Annexure B.
Yes.
Because, Your Honor, there is on 25th, it is a matter set down for a trial.
Let it go. Yes, next.
Cell number 44, Keshav M. Datar for petitioner. H.V. Devraj. Because Hussain.
Your Lordship, I appear for the
Your Honor,
respondent.
date may fix, Your Honor. Any date may fix.
It's about on 16th of September.
Your Lordship, I request a short date. Your Lordship, there's a.
What is this early hearing? IA 2 of 26.
Yes, Your Lordship, that was filed by respondent number 4.
They had also filed an application for early hearing. We had also filed an application for.
It's a WP of 2022.
Please, minutes. It's a short question for consideration.
Yes.
Minutes, may I?
I have a lot of other matters. No, I can't take up this matter.
No, it's a short matter, Manoj. If my lords
No,
could
she's
take,
asking, when do you want?
Day after tomorrow, Your Lordship, the personal emergency.
maybe listed in preliminary hearing, Manoj.
Why?
No, it's because it's been, they've been procrastinating the proceedings from, there is a Supreme Court
They have to
direction
tomorrow in the
also to
first
that
list.
effect.
You have to tomorrow in the first list. Yes, next 45.
Grateful. My lords.
For the respondents in this, my lord, we have filed the application for vacating stay. The reason being, my lord, the petitioners have mainly contended that consent of the petitioner is not obtained prior to drawing of the transmission line. My lord, with regard to that, section 10 of the Telegraph Act, my lord, authorizes the KPTCL, which is the telegraph authority. My
Where is
lord,
the order sheet?
Lord, similar matters, your lordships have already rendered decision. They have remedy under section 16(3) of the Telegraph Act.
Was interim order granted?
12/12/2025, my lord. Except for the petitioner's land, my lord, the project has been implemented so far as other lands are concerned.
My lord, the impugned order.
But you can't stall the process for a period of 1 year. Larger public interest,
Lord,
please.
may make a submission. The impugned order is 27/8/2024. As on that day, my lord, there was no order passed by district commissioner.
For what? When will the district commissioner
Regarding
will
the
pass an order?
compensation, they have passed the order on 24/10/2025. I was not heard there, my lords. This order, earlier to the impugned order, they have not passed any order regarding compensation. Only after the impugned order, they have passed this order in October 2025. Under 16(3), my lord, I'll approach the district judge for regarding the compensation.
Yes.
On that.
Yes. The writ petition is filed. In the following prayer. And a coordinate bench of this court.
Lord, I'll pass on your lordship's decision.
On 12/12/2025 has passed an order. Whereby the respondents are directed not to interfere with the petitioner's lands, including by installing any electric towers, poles, transmission lines until the next date of hearing. When counsel appearing for the respondent filed the vacate petition, she relied on a order passed by this court in WP number 104689 of 2025. In case of Sri Gangadhar Reddy and other, was the Karnataka Power Transmission Corporation Limited and another. She relied on paragraph number 9, whatever it is. So, wherein this court has permitted the, as disposed of the writ petition, directing the petitioners therein to make appropriate application to respondents 1 and 2 by 10/2/2026, the date not required for respondent number 1 and 2. And within 2 months, they shall consider their representation, pass orders in accordance with law. And counsel for the petitioner submits that. So far, they have not determined the compensation.
Now, after the impugned order, they have determined the compensation.
And
They
you're
have
not, you're unhappy with that.
I have not been heard.
No, you're not happy with that compensation. You will go before the court.
I'll go before the district commissioner also, because this is the reason, my lord. What they are installing is towers. Regarding installation of tower, the district commissioner has not passed any order for compensation. It is for
Submitted that, then counsel for the petition submitted that. Now, the respondents have, the deputy commissioner has determined the compensation contrary to the settled law. Hence, will go before the court under section 16(3) of the Telegraph Act. Considering the submission of the land counsel for the petitioner, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy under section 16(3) of the Telegraph Act within 2 weeks from the date of receipt of the copy of the order.
16(3) for before district judge, my lord. My
District
submission.
judge.
Yes. Before district commissioner also, I may be permitted to approach, because they have not passed any order, any compensation regarding installation of towers. Only
The court will grant you. Why do you unnecessarily want to
Great.
waste your time? The 16th.
Bill number 46.
Oblate.
J. Kumar for petitioner, Lakshmikant K.
He wants to withdraw the amount.
No, my lord,
Deposited.
it cannot be, my lord, for the reason. There is a dispute with regard to the possession of, delivery of possession of the scheduled premises. A portion of the
What is the order? What is the order that is passed?
interim order also is being directed to deposit the remaining rent, the disputed rent, with a direction to deposit in a bank, a fixed deposit, subject to result of the suit.
Subject to the, till the next date of hearing, subject to the petitioner tenant deposit and admitted rent of 35,000 of the ground floor to the respondent landlord.
I had completed the order as per this order.
No. Subject to condition, the petitioner tenant pays an admitted rent of 35,000 of the ground floor to the respondent landlord.
That is been paid. That is not in
Paid.
dispute. That regularly we are paying before the
They have
trial.
deposited the, in this regard only, they have deposited the sum of rupees.
No, they-
And the
like
petitioner
more than
tenant
10
further
lakh.
deposits the balance amount
Yeah,
before the trial court along with the arrears within a period of 6 weeks.
Yes, my lord.
That is
Trial
been
court, the same
deposited.
shall be kept in fixed deposit in a national bank. Why should it be kept in a national fixed deposit?
No, my lord, there is a dispute with regard to the delivery of possession. The scheduled premises was being leased a 2-3 portion of the premises, my lord. Ground first and the
Please
terrace.
come to
first.
the impugned order. Let's see. Instead of keeping this pending, we'll decide this so that
No,
whatever
impugned
follows
order, my
will
lord,
follow.
impugned order is the annexure L.
Page number.
One not, 107, my lord. Down to page number 109, my lord. Case called defendant counsel filed a memo submitting that defendant has deposited 4 banker check of the 35,000 each as stated in the memo. The checks are issued to the plaintiff's wife. Hence, this memo is filed for reference of the court. Plaintiff is examined as PW1. Exhibit P1 to 7 are marked. Defendant counsel praised time for cross-examination. That has been rejected on the same day on the ground that I had not fulfilled the entire amount rent has been deposited. So for cross-examination, no opportunity was
Peruse the
given.
memo filed with the defendant who has provided information regarding payment of the rent by way of checks.
Check.
To be
But that
paid
is the
from
regular
till
admitted
But an
rent,
execution bearing.
which
In
I
view
am
of
in
not
possession
compliance
is
of the
paying
court
rent.
order dated, adjournment is not given. Today, cross-examination.
The
Yes.
disputed amount, my lord, the remaining portion which has not been delivered, that rent was, in fact, has
Now,
not been deposited.
an
That came to be
order-
ordered by
an
this
order
court to
passed by
deposit
the-
it before
An
the.
order passed by the court has been affirmed in the appellate court. Why should we pass an interim, by way of interim order, contra order?
That is the dispute, my lord. That is the reason
you have
why
not
I'm before.
questioned.
That is the dispute. That has to be go for a trial and establish me whether the
When did you
possession has
question
been,
the order
whether I am
passed in
entitled
MA?
to pay the, my lord.
When did you, where did you question that order passed in MA? MA,
That is what I am before this court in the man of the questioning the interim order at the at page annexure L.
you said 110.
Please, my lord.
110
That
is not that
opportunity was
order.
not given. That has been questioned before this court. On the ground, the MU is been, that is still under consideration, my lord. No doubt the MU order has not been challenged. There is a direction to pay the rent.
Whatever is the order, MA order, you have to comply. If you don't comply, the court was right.
My lord, that has been, now this court has been considered
No,
that
we can't
aspect
consider.
also.
There is a question of we considering MA order when that is not the
That
order.
is not the MA order, my lord. The order which has been considered by the trial court is been considered by this court and admittedly, since I am not in possession and not entitled for the.
Please understand. You are before this court wherein your right to cross-examination is taken as nil. You have come before the court.
Please.
We have to only decide about the legality of that order. Where is a question of passing an order, basing on an order passed in MA, which you have not even questioned? This interim order ought not to have been granted.
This interim
Please
order
come.
has been.
You pay the amount as ordered in the MA. If you pay that, you will get a right to cross-examine. That would be the order. Otherwise, no.
No, my lord, may I have it next week, my lord?
Yes.
I have it next week.
Interim order, I will not extend.
No.
Or else I'll have it tomorrow. Already tomorrow is the first case.
No, let it be on after 5th, my lord. Let it be on after 5th.
No, he wants to withdraw the money.
No.
If
Let
you say
it be on 5th. I don't mind the interim order may not be extended. Let it
Yes,
be on
yes.
5th.
No interim order extended.
Please.
My lord, the amount they have paid,
That
that
has
is
been
the
already
admitted,
deposited,
admitted.
deposited, fixed deposit is been ordered, fixed deposit is
Yes,
been made by the
fifth,
trial court.
don't extend the interim order. List this matter on 7th of September. Yes.
Please.
47, Giri Kumar SV, petitioner. 47,
The disconnection of the power, connection of the power and challenge the impugned order at Annexure J, which is in Kannada, my lord. If my lords may consider,
What is this for? 26 matter early hearing?
my lord, power is not there for more than 10 years, my lord. Power disconnected for more than 10 years.
What are your instructions?
That's I have to seek instructions, my lord.
Then what for you are coming to the court without seeking instructions? It's a KEB matter. Just asking the client why they have disconnected the power supply.
No, ma'am. No, my lord. The power connection was disconnected in the year 2015 itself. 10 years they have survived without the power connection.
Is it?
Yes, ma'am.
And you file a writ petition in
Second round
26?
of writ petition, my lord. First
And
round.
IA for early hearing. Respondent shall file the objections. This is matter in the month of September. Yes, next.
Any date, please.
Production.
First week, my lord.
Yes.
The state has to file objections in this matter, my lord. Pray for time, my lord.
My lord.
The state has to file
With
objections.
regard to the excise license, my lord, last time they have taken time to file an objection to the main petition.
How much time you require
In
to
the
file
meantime, I
objection?
have filed an application.
The draft is ready, my lords. All that we need to submit is the translation copy of it.
When will you file?
One more week, my lord.
And also
Because
to the-
translation takes time.
Is the matter on 2nd of September for the objections of the respondents. If by 2nd, if the objections are not filed, the respondent's right to file the objection shall be forfeited.
And also with regard to the application filed. And also with regard to the application filed for amendment, that has to be.
Whatever it is, whatever they have to respond, they'll respond. Yes.
49, Bhaskar Gowda NM for petitioner.
No representation. This is in the month of October.
For preliminary hearing, cell number 50,
My lord, in this
Ramesh
matter, my lord, I am
KR.
appearing for the petitioner. The connected matter, my lord, your
Counsel
lordship
for
already granted.
respondent.
Notice was issued. The same matter may be issued notice and call along with, my lord, WB numbers others.
Kindly connect the matter.
That's what he's also saying. List along with so and so.
Copy not surrounded.
But he is not entering.
For the copy only.
Notice was not issued.
Notice, it's already, I think, before that only. So the paper.
Please.
You appear for all he appears for all the respondents. Only one respondent.
One respondent. He is also one
Respondent
respondent.
number 1.
Or one
How many respondents are there?
respondent and another.
In the present matter, my lord, two respondents, my lord.
You appear for whom?
1. Respondent number.
Yes, notice to respondent number 2.
My lord, sorry, it is only one respondent in this matter.
Another consider.
Hanumantaraya,
Yes.
sole respondent.
List along with so and so. No other things. Only list along with so and so.
Notice.
Cell number 51, Illa.
Public.
He's already there. Why not?
But he is not filed Vakalat. Please, otherwise, we will undertake this.
Not required. He is there.
Cell number 51, Kempe Gowda.
Defendant's writ petition, my lord. Written statement was taken as not filed. 19 days delay was there.
Notice and summons.
My lord, 24th evidence is there.
Then counsel the petitioner submits that. The court has failed to take the written statement on record. As the same is filed with delay. It is submitted and seen that all written
24.
statement matters. Yes. 52.
Cell number 52, Manoj SN.
Close it. Writ petition by the defendant seeking for early disposal. My lords, there's another matter, my lords, WP 4121 of 26, wherein the plaintiff's IA for amendment came to be rejected. Assailing the said rejection order, my lords, there's a writ petition was filed in 4121 and a stay has been.
Why should we dispose of the 2020 suit with expeditiously?
Well, the IA for amendment was filed at the stage of arguments.
Forget about it. You are seeking disposal of the suit. Why should this court grant?
Well, it's been 6 years, my lords.
6 years.
6 years since the filing of the suit.
Only 6 years.
Maybe connected along
Petition
with.
is filed so and so in the light of the law laid down with the honorable apex court in so and so in this court in a routine manner cannot issue a mandamus, and this is not an exceptional case where the court has to issue direction to the court to dispose of the matter expeditiously. Hence, this court do not find any reasons dismissed. Yes.
Cell number 53. Mother Shridi.
Defendant's writ petition, my lord, suit for partition, my lord. I had sought for amendment to include one paragraph, my lord, in the written statement, and also the scheduled property which was left over, my lord. It is rejected.
For partition.
Suit for partition, my lord.
Which year is the suit?
Suit is of the year 2020, my lord.
Come to the order.
Lord, order is at page number 45, my lord. The learned judge, my lord, it starts from 45, my lord. The reasoning is, my lord, judge says that the learned trial judge says that one or the other party is filing application and it's being protracted, and so on that ground it's rejected, my lord.
Please come. When comes to the petition submits that an application is filed under Order 6 Rule 17 seeking amendment to the plaint. The court, without considering the merits of the matter, only on the ground that the applications are filed one after the other, had dismissed the same. Considering the submission of the counsel, there shall be stay of all further proceedings. Question to the order dated so notice and summons. Yes.
Cell number 54. Jo Kumar ji.
No representation in the month of September. Is 55?
Cell number 55. Nanjunda.
Yes. In the month of September. 56.
Cell number 56.
Appear for the petitioner, my lord.
Yes.
The respondent number 1 filed a FTP proceedings before the trial court, my lord. In the during the pendency of the FTP proceedings, the honorable trial court has appointed the court commissioner to take steps towards the conducting the public auction of the scheduled properties, directing him to ascertain the valuation, my lord. In the valuation, the court commissioner has submitted the valuation report, my lord. In the properties, measurement is not accurate, my lord, and the valuation submitted by is also inaccurate, and the scheduled property 6 is also left out.
Where is the order?
In page number 19, my lord. The objection filed by the respondent number 3 to 5 for the court commissioner report dated so and so are hereby overruled. The court commissioner report dated 28/2/2026 along with the revised valuation statement and the gazette notification is hereby accepted and they taken in record. And the valuation furnished by the commissioner shall be treated as the reserve the value and guiding the value for the purpose of further proceedings in the final decree proceedings and subject to.
None comes to the petition submitted. And the petitioner has raised objection to the commission's report. The court, without considering the objections as raised by the petitioner, has simply brushed those objections aside and rejected the same, considering this there shall be stay of all for the proceeding. Yes, next.
Cell number
Notice
50.
and summons. Yes.
57. Shankar Narayan Bhatt.
Here, the plaintiff's application for amendment of plaint was rejected. The
suit is of 2013. What is the suit for?
For bare injunction, and the petitioner was an agreement holder. By paying the major portion of the consideration amount, he had entered into.
What is the amendment you are seeking now?
I sought for a specific relief, seeking for a specific performance of the agreement.
2013. Basing on the specific agreement of sale, you sought for an injunction.
Yes, madam.
And now you seek specific performance in 2020. When?
21.
20?
21.
Yes. Come to the reasons.
Annexure C, page 19. The defendants, the first defendant remained unserved, my lord. So, yeah, the second defendant was later included into the proceedings.
Yes.
The only ground made out was that the application was barred by limitation. It is an amendment seeking specific relief. It could have been
the limitation is a question of fact and law, which could have
Not
been
at all, not in every case. Please come. The agreed with the order passed on I number 5 in OS number 329 of 2013 by the Civil Judge Unit Division at Bangalore, Rural District, Bangalore, dated 10/4/2026. The petitioner plaintiff is before this court. Originally, the petitioner has filed a suit for injunction. Later, an application is filed. Order 6 Rule 17 seeking amendment of the prayer. Now, he is by virtue of the amendment, he is seeking the relief of specific performance that came to be dismissed by order impugned. While dismissing the application, the court has observed that on perusal of the documents and pleadings available on record, it could be seen that the plaintiff has filed the present application on 12/11/2021, and the suit was filed in the year 2013 after lapse of 8 years. The plaintiff has come up with the present application for amendment of plaint and for amendment of prayer column for the relief of specific performance. It is well settled that limitation period. The request for amendment must generally be filed within 3 years limitation period for seeking specific performance. Therefore, an amendment to convert a suit for injunction into one for specific performance can be allowed if the facts support it, although it is not permitted by a simple direct conversion. Such amendments are generally accepted if filed within the statutory limitation period, particularly if the breach occurred before the performance of the date. Moreover, if present application is allowed, it will alter the nature of the suit. Cause of action will be changed. Hence, rejected the application, and counsel appearing for the petitioner submits that the court ought not to have dismissed the IA filed under Order 6 Rule 17 seeking amendment of the plaint and also the prayer on the ground of limitation. It is submitted that limitation is a question of fact and law, and that cannot be decided at this stage. Further, it is submitted that when an application is filed seeking amendment of the pleadings, the court cannot look at the validity of the said amendment at the inception. Next para. Having got the further land counsel, the petitioner appears a material non-record. The suit is filed way back in the year 2013. Even on that day, the petitioner has mentioned about a agreement of sale. Now, in the year 2021, he wants to amend the pleadings by inserting the payer, the specific performance. Now, the petitioner which is not permissible directly, is trying to do it indirectly by amending the pleadings. Even while amending the pleadings, while seeking a prayer which is time barred, on the face of it, cannot be entertained. And apart from that, the entire cause of action for the entire nature of the suit will change. And by allowing this amendment, it would cause lots of hardship to the defendant. All these aspects are rightly considered and dismissed and rejected the IA, and this court finds no reason. It's 58.
Cell number 58.
Millards, I appear for the petitioner in this case. Millards, this is plaintiff's petition challenging the order passed by the trial court rejecting the application under 6/12/17. I wanted to insert 3 paragraphs pursuant to an order passed by the same court in a connected suit between the same parties, whereby the Honorable Court has held that a management development agreement is invalid and unenforceable. Therefore, it has set aside the arbitration award. I just wanted to insert only that subsequent event in the plaint, which is directly connected to the present declaration suit, which was filed in 2014. Admittedly, for a declaration, I'm not changing the nature of the suit. I'm just pleading subsequent event, which happened in 2025, which directly has a bearing on the management development agreement, on the basis of which, at the back of me, the defendant number 1 has executed a sale agreement in favor of defendant number 2. The Honorable Court, same court, has held that the management development agreement itself is invalid and unenforceable. Therefore, it has set aside an arbitration award which has annulled the management development agreement. So that aspect, I just wanted to plead in 3 paragraphs. Your Lordship would get the relevant portion at ink page 34.
No, please come to your IA.
Millards. Page number 40, Millards. It is an admitted, May I please, Your Lordship? May I read?
Yes.
It is admitted fact on record that even prior to April 2004, the suit schedule property had been acquired by the Bangalore Development Authority and continued to remain. This is the amendment I have sought.
The application is filed in order 6 to 7 days. Only on the ground that the same is filed after commencement of the trial, the court has dismissed has rejected the application. It is submitted that the court ought to have considered the merits of the matter instead of going purely on the technical ground that the amendment is after commencement of the trial, considering the sufficient state. Notice and summons. Yes, next.
I may be permitted to serve the notice on the other side. A date may be fixed, my lord. Very
Call
short.
till
matter.
60. After that,
A date may be fixed, my lord.
The land summons.
For the petitioner, my lords. My lords, the respondent number 1 and 2 have filed a suit for partition, my lords. And the respondents number 29 to 39 herein, they have filed an application under order 1 rule 10 to implead as proposed defendants number 31 to 41. When they are not the necessary parties, my lords, they are saying that they are the children of the second wife, which is incorrect, my lords. So on that.
you have decided.
No, my lords, these were my instructions.
Very sad. How can you say now that it is not correct? Where is order?
Page number 52, my lords.
50?
52.
The proposed defendants or the co-sharers have stated by them in their affidavit with respect to their rights and share is concerned, it requires trial. Hence, at this stage, court is of the opinion that it would meet the ends of justice.
Notice may be issued, my lords. My senior will address the further arguments.
Because notice is not required in this.
My lords.
Let your senior come. I'll not issue notice. Let him argue. When?
Short date, my lords. Next week.
Mrs. Mata on 3rd of September. Yes.
60, Sundaraman MV for petitioner.
Not for the petitioner in this matter. My lord, a suit for partition. The petitioners, my lord, are mother and daughter, and the respondent is the son.
What are these two petitions? Two writ
My lord,
petitions.
there were two IAs because
One
of which
is?
we had to, because of office objection, they had to be
One
filed.
is?
Temporary injunction. One is for appoint. My lord, IA 3 is for appointment of receiver. One is for access to.
No, one is appointment of?
My lord, IA number 3 is for appointment of receiver, which is the second writ petition. The first writ petition, my lord, is with respect to IA 1. Which is
Lord, if I may be
permit
permitted to
access.
appear online, my lord, for the respondents.
No, you
I
have not
undertake
filed any case. You have not filed any
Yes.
caveat.
My lord, we have not filed a caveat, my lord, but we undertake to file a wakalat on this, and we may be heard, my lord, before any interim order is passed. Also, my lord, if I may be permitted to make one submission, it is listed before the trial court for orders today, my lord. It has to be. It is listed today for orders, which has to be passed, my lord.
Yes, which is true. It has been listed for orders on all days, my lord, from 4/8. Every day it is listed. Which because of which, my lord, we got this petition, my lord, adjourned on 2 prior occasions, saying matters posted for orders. But every day it is listed, and my lord, no orders from February onwards, my lord. These applications are pending. My lord, can I request, my lord, to kindly first look at page
What is the order
199.
you're seeking now?
My lord, is for a direction, my lord, that these IAs 2, 1 and 3 be disposed of expeditiously, because, my lord, while passing a preliminary
The court heard these IAs.
My lord, can I request my lord to kindly look at the, my lord, may kindly look at page number, my lord, kindly look at page number 4 in the list of dates. My lord will see that this petition was, my lord, the respondents filed their objections in, my lord, applications are of October last year. Respondent filed their objections in December. Then, my lord, the matter was heard on 5/1. The respondents were heard on 27/2. Then, my lord, the matter was posted for orders. Then, my lord, it is then immediately after reopening, my lord, there was a change in the learned presiding officer, because of which the matter was again argued. So, my lord, kindly see, we argued this.
So in both
on
the matters,
1/6.
you're seeking direction.
I'm seeking directions.
The writ petitions are filed, saying the following prayer. It is submitted that the matters were heard long back and continuously the matters are posted for orders. No orders are pronounced on the IAs considering the same. So and so, this court is passing the following order. So and so is directed to pass appropriate orders on the IAs within a period of 1 week from the date of the receipt of the copy of the. Yes.
My lord, can I take hand delivery? My lord, it's listed. It will be listed again tomorrow. I will take hand delivery and pass it on.
It will be it will be by tomorrow evening, it will be uploaded.
230 mentioned matter, cell number 94.
No. Come. All these matters from 60 to 95. Let it come tomorrow. Then this CRP, sir. Fresh CRP, fresh CRP, sir. Let it continue. Then this orders matters are there. Now this 109 who appears?
Cell number 109.
109.
Akinga Reddy and
This in the month of September. 110.
cell number 110.
This also September. 111.
11.
In all these matters, look at it. If interim order is there, extend.
113. Raja Nitya Sadasivan.
All September. 114.
114. Maya Mulla.
This also September.
115.
September.
Cell number 116.
September.
Cell number 117.
But look at it. Interim order extend. Yes.
17.
18 also
Cell
same.
number 18. 119.
Avoid service of notice issued to R1 memo of hand someone. You have served? All are served? Then counsel for the petitioner submits that he has filed a memo. As per the order, he has taken out the hand summons and filed a memo to that effect. Accordingly, notice to so and so is hence sufficient. Look at the file. Yes, 120.
120.
List after service of notice.
Cell number 121.
List after service of notice. Look at it in all that interim order. 122 list after service. 123.
My lordship, I am for the petitioner, my lordship, in 123. Will comply the office objections, my lordship.
Within 1 week, office objection shall be complied with. 124.
And any date may be fixed, my lordship.
On 9th of September.
My lords, 124, please permit me to withdraw the petition, my lords.
Take that.
124.
The petition has liberty to withdraw this petition with the liberty to file appropriate petition. Accordingly, the petition dismissed as withdrawn with the liberty within 2 weeks. Next.
125.
125.
Nandish KR.
Next. Office objections to be complied with within a week.
Cell number 126.
No. This 125, let it be there in the list. Let it be there in the list, 125. 126.
Cell number 126. 126 something.
Let it be.
127. Cell number 127.
Yes, someday in September. Yes,
Cell number 128.
same.
Cell number 129.
Why all of them have come in the first list? Why they have come? All these are all date matters. Why they have come in the first list? Don't think so. Yes. This 130 notice, 131 notice,
Cell number 132.
give a date. 132.1, give a date.
Cell number 133.
Yes, this in the month on 23rd of September.
Cell number 134. 134. Gautam Mia.
This is 2025 matter. No, stay. Let this be on 9th of September.
Cell number 135. M.N. Satyaraj.
Let it be there in the list
130. Cell number 136.
tomorrow.
Cell number 137.
Let it come on 9th of September. Yes, 1:30.
139. Vandana PL.
May I, my lord? This is the case, my lord.
I'll
which-
take up the 2:30 mark.
Greatly.
Huh? That was.
Serial number 140, appear per petitioner, my lords. Kindly press time.
Huh?
Petitioner 140, serial number 140.
You want time? Somebody has moved the court. Other side. You must be having stay.
Yes, ma'am.
That's why you don't want it to be heard. Let it be there. Let it be there in the list.
Interim order extend.
Let these matters be there in the list. Yes. Now call
230 mentioned matter, cell number 94. 94 one side. 230 mentioned matter. Yes, Rajshekhar.
Where is it?
Westcom.
Power disconnected.
Notice is given to whom?
Yes, BS Karthikeyan has taken notice.
Tomorrow. Let it be in the first list. Top of the list.
Yes, top. Cell number 139. Vandana PL for petitioner.
Lord, now the order of the entire trial court, my lord, is placed.
No, every day, every matter, why it becomes urgent?
I mean, it's not an urgency for me, my lord. They pushed it.
What is
21
urgency?
years, my lord.
For saying that about not to
Execution of,
precipitate.
execution of award is stalled.
My lord, after
That's the reason.
21 years, they're challenging the authorization, my lords. There are 3 rounds of litigation priorly held.
It's
my
open
lords.
for me to do that. Lord, it's something which is, my lord, I am supported
Even
by
the
my lord
apex
4
court has
judgments.
confirmed the confirmed enforceability of foreign award, my lords. Now,
There is
now they file this procedural application, my lords. That is challenging the Order 3 Rule 2 application, my lords.
What
There's
is
a
the
power
order?
of attorney
Give the order
present in
sheet.
the
Order
file,
sheet.
my lords.
The order, my lord, is filed along with the application. Earlier, it was not there.
Oh, this is
That
a
was
case
precisely your lordship's called for, my lord, an
only
office
on that
report.
ground.
Yes, my lord.
Yes.
What is impugned order? Where is impugned
The
order?
impugned order, my lord, is now placed along with the application. Your lordships may kindly see that. One for additional ground, once, my lord, one placing, my lord, the impugned order. My lord, the order is at page number 5. My lord, I'll be taking some 10 minutes time on this. Your lordships may kindly bear with me.
Let me first look at that order. Where is
Yes,
order?
your lordships would kindly have it, my lord, at page number 5.
Filed when?
My lord, it was filed 17th, my lord, along with, my lord, an application. It is listed, my lord. It's, in fact, the applications are put up.
Yes.
Your lordships has it. Page number 5, my lords may kindly see. My lord, this is the orders on IA number 14. My lord, precisely, we filed an application under section 47 of CPC.
You are the judgment debtor.
I am the judgment debtor. Precisely, we filed an application, my lord. These are not, my lord, a regular decree. This is a foreign award. My lord, under Arbitration and Conciliation Acts, your lordships are aware. My lord, the second part of the act, my lord, starting from section 47, deals with enforceability of foreign awards. My lord, unlike a domestic award, which is a deemed decree, a foreign award, my lord, has to be first recognized by, my lord, the jurisdictional executing court. Once it is recognized, an order of recognition is passed, then it becomes executable as a decree. Now, my lord, I have 2 levels of, my lord, laying challenge. One, it cannot be recognized. My lord, that part we have completed. We went, my lord, we came before this honorable court. Initially, my lord, it was held to be, it was recognized. We came before this honorable court. This honorable court, my lord, overturned the order of the executing court. We were remanded back. And my lord, they also took much time. My lord, it's not that one hand, my lord, we were able to clap. They also were there. My lord, a lot of time passed. And finally, an order came to be passed recognizing the award in the year 2025. Now, my lord, then we came before this honorable court. This honorable court, my lord, upheld that order. The matter went till the honorable Supreme Court. Finally, the honorable Supreme Court said, yes, the award is recognizable. Now, my lord, that part is over. Now, once the award is recognized, then, my lord, it would be executed as a decree. Now, my lord, we are at that stage. Now, the executing court is executing a decree. Now, I get a right, my lord, under section 47. The first part, whatever my learned friend said, that it has consumed 20 years, my lord, there is no disquarrel about that. It was all on recognition. Your lordship may kindly have, my lord, Arbitration and Conciliation Act, my lord, for a moment. Section 47, my lord. This is part 2, starts with section 44. Your lordships may kindly have section 47.
Yes.
The party applying for enforcement of a foreign award shall at the time of the application produce before the court the original award or a copy thereof duly authenticated in a manner required, the original agreement for arbitration or a duly certified copy thereof, such evidence as may be necessary to prove the awardee is a foreign award. If the award or agreement to be produced under subsection 1 is in foreign language, the party, etc., etc., then kindly, my lord, go to 48. My lord, this is the important section. 48, my lord, section 48. Enforcement of a foreign award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the court the proof that the parties are agreement, etc., etc. My lord, these are similar grounds as are under section 34. My lord, once the award passes through section 48, that is, that the court would pass a preliminary order saying that yes, award is now enforceable. Now, your lordship sees 49, where the court is satisfied that the foreign award is enforceable under this chapter, the award shall be deemed to be a decree of the court. 20 years, no quarrel was spent, my lord, convincing the court that the award is not enforceable. Now, my lord, there is a judgment of this honorable court against me. My SLP has been dismissed. There's absolutely no issues about, my lord, the quality of enforceability of the award. Now comes the execution proceedings. What is pending before, my lord, the court below now from 2026 is execution proceedings. Now, your lordships may kindly have section 47 of the Civil Procedure Code. Nagaprasanna Sagar judgment. Now, my learned friend to say, my lord, the entire time is consumed under this is incorrect. Lord, 47, questions to be determined by the court executing a decree. All questions arising between the parties to the suit in which the decree were passed are the representative and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate court. Now, my lord, we filed an application under section 47 saying that if you want to seek execution of a foreign award, which is now recognized, you must seek along with the execution petition, there is no board resolution. My lord, which is a sine qua non. My lord, I am padded by one honorable Supreme Court judgment, my lord, two judgment of, my lord, two other constitutional courts. Your lordships may kindly have, my lord, our honorable High Court's reported judgment on the scope of 47. My lord, very limited. I am going to read only one paragraph. Your lordships may kindly have paragraph number 26. Your lordships may kindly have page 26, my lord. After, my lord, the bold letters emphasized portion. In this case also, my lord, we filed an application under section 47, which was dismissed by the court that no, you can't file section 47 application opposing enforcement of a decree. This honorable court, my lord, found page number 26, my lord. After, my lord, the bold portion. In that light, the application so filed by the petitioner invoking 47 of the CPC to hold that the concerned executing court did not have jurisdiction was in tune with law. Now, my lord, our application was allowed, execution proceedings were terminated in this case. Now, my lord, we filed an application under section 47, primarily realizing one objection. That is, you have not produced a board resolution to seek enforcement of this decree for the executing court to proceed with. Now, my lord, the learned trial judge heard their objections, our objections. Please see, my lord, what the learned trial judge does. Not even, my lord, consideration of whatever we, my lord, pleaded in our application. We simply said there is no board resolution. My lords, may kindly go to, my lord, page number. One second. Page number 13, my lord. Page number 13, fourth line from the top. My lord, this is their objections which is captured. Fourth line from the top. It does not prescribe any mandatory condition affecting the inherent jurisdiction of the court or maintainability of the proceedings. The execution petition having been filed through a duly constituted power of attorney holder falls squarely within clause A of order 3 rule 2 without prejudice, even assuming that any defect in the authorization, the same would be a procedural irregularity capable of being cured, invalidate the execution proceedings or render them void ab initio. It is settled law that the procedural defects relating to the representation do not invalidate the substantive proceedings. The objections raised therefore is totally misconceived. My lord, they said non-production of a board resolution is something innocuous, insignificant that has to be overlooked. This is their argument. We said it is a strong and mandatory requirement of law. Without a board resolution, a corporate entity cannot hold proceedings either on original side or on execution side. This was what our case. Now, please see, my lord, paragraph, my lord, page number 9, page number 19, 19, internal page number 15, till paragraph number 8, which is on the bottom quadrant. It's all, my lord, extraction of the pleadings by both the sides. This is what, my lord, the court says. Paragraph 8 onwards. If it is summarized, if it summarizes the controversy.
Where are your objections? Let me look at it.
I beg your pardon.
Where are your objections? Under section.
My application.
Yes.
My application,
Yes,
my lord.
number 201 of the petition, my lords, their application.
Yes. My lords, may kindly have page number 201. A detailed, my lord, kindly, my lord, see paragraph number 6, my lord, on page number 203. This is what is my objection, my primary objection. Paragraph number 6, my lord. I state that no board resolution of the DHR company has been produced either along with the execution petition or thereafter. In the absence of such board resolution, the alleged power of attorney has no legal basis. The person prosecuting the execution lacks authority to represent the DHR company, and the execution petition has been instituted by an authorized person. My lord, then at paragraph number 8, I say how I am invoking
All the while, who is prosecuting this on behalf of the respondent?
I'll come to that. I'll come to that, my lord. We took these objections, my lord, even during, my lord, section 48 proceedings. That is, my lord, recognition. Since, my lord, the court held against us.
What was
the honorable court, my lord, that was the recognition proceedings. There, my lord, we said, we in fact took these objections. We in fact, my lord, took other grave objections. Number one, original arbitral award till today is not placed. Till today, my lord, the original award is missing. We don't know where it is. Number two, we said about the power of attorney. But, my lord, this honorable court held that it is executable. We lost, my lord, the SLP. Now, I am not going to make much noise about that. The honorable court has held that the award is recognized and it is enforceable. Now, my lord, who is enforcing it? Even for the purpose of enforcing, my lord, there has to be a board resolution, which is lacking. That's what, my lord, I said under section 47. Please look into this aspect. Not in a separate suit. Please look into this aspect. The court, my lord, would take all our contentions, my learned friend contentions.
So, section 47 is only on this ground.
Well, section 47 is the power of the court to determine all questions raised during, my lord, the execution.
What you have raised?
I have raised this.
See one.
Yes, precisely correct. One second.
That the power of it, that the GPA is
there is no board resolution. Board resolution.
That's the only ground.
That's the only ground. Now, my lord, your lordship also sees. Kindly, my lord, go to page number 204. Kindly, my lord, see another, my lord, grave objections we took. Paragraph 15, my lord. I am not having any animosity against, my lord, Korea, but, my lord, we said it. I said that DHR is a foreign company incorporated under the laws of Korea and does not have a registered office, permanent establishment, or principal place of business in India, and where a foreign corporate entity seeks to invoke the jurisdiction of Indian courts through alleged local representatives, strict proof of authorization assumed paramount importance. But we said this. Of course, my lord, I bow down and I agree. I can perceive, my lord, what falls from your lordship's mind, that, my lord, this could be somehow or the another attempt to, my lord, drag. My lord, I would put it this way. I would, my lord, this is what my learned friend is also going to
That's
say.
what experience matters.
Exactly, my lord. My lord, I have to be fair to the honorable court, my lord, as at least as a senior member of the bar. My lord, of course, I don't, my lord, say, my lord, if this application was rightly addressed, Lord, I lose grounds. No, my lord, I might take very feeble, innocuous grounds. But, my lord, law gives me that. Your lordships may kindly see, my lord, 3 judgments I am going to read. Our Honorable Supreme Court. Lord, the Honorable Supreme Court says, in the absence of board resolution, please don't look at anything. At any stage, please don't look at anything. And, my lord, the Honorable Bombay High Court says in Nibro, my lord, which the Honorable Supreme Court cites, my lord also says, without board resolution, a corporate entity, unlike an individual, talks only through its resolutions. My lord, I am not saying, my lord, I should have won over this application. The learned judge should have at least dealt with the application. My lord, learned judge would not do anything. Learned judge would simply say.
To your credit, you have 20 long years. This is high time that you should do.
I understand, my lord, 20 long years, my lord, they also, my lord, in fact, collaterally.
So for this kind of the
this
manner in which
contention
our
was never taken
no, the
before.
manner in which we are
It was
working,
taken. I can show it now. Let us not dig into the original records. Then I'll consume one more day.
manner in which the things are working out and how conveniently the
I will, my lord,
litigants are
I will-
getting the time.
I understand,
That's
my
why the foreign companies are afraid of the country.
I understand, my lord. I understand, my lord, what the Honorable Supreme Court has said. Arbitral award, unicitral has to be strictly followed. Otherwise, the commercial credit of the company will go. I understand that, my lord. But, my lord, the Honorable Supreme Court has also said, if you see, there is somebody who is sitting at a foreign country, is resorting to all kinds of activities. Maybe sometimes even an arbitral award is a fruit of fraud. Where it can be tested, only, my lord, invoking that virtuous jurisdiction which is vested in our courts, which deals with public policy, the concept of public policy. Lord, your lordships may kindly appreciate, though I have lost, kindly see, my lord, what is the ground which I set. We took one primary ground. Initially, the arbitration was done by a particular arbitrator. My lord, 1 second, sir. I would beseech your patience for some time. I understand that you are standing on the threshold. Allow me, please. My lord, one Brown Harris was the arbitrator. Suddenly, my lord, they give a go-by to him. Somebody else, my lord, becomes an arbitrator without even notice to us. Now, my lord, we brought a list before this honorable court. I have no issue. Earlier, the arbitrator was somebody else who was sitting consciously under English law to deal with the arbitral dispute because agreed law which was to be applied for the purpose of arbitration was English law. One fine day, my lord, he is given a go-by without any reason, and another person, my lord, comes in his place. That is another. 1 second, sir.
My one submission, my lord.
Sir,
We are
1 second.
We are traveling
My lords may kindly,
out
my
of
lord.
the scope of the writ
Yeah.
petition, which is already attained finality, my lords. Now, if we go back and adjudicate the very same matter,
Sir,
which is already
can you bear with me? You will get your chance. I will not interrupt
My
you.
lords, let
No,
us
why
come
are
to
you
the writ
interrupting me?
petition is what I'm humbly requesting.
My lord, we said another arbitrator is replaced. My lord, they contested that. We contested that. My lord, 20 years did not, my lord, it did not flow under the stream, my lord, just because of me. They also contested it tooth and nail. And your lordships may kindly appreciate. In 2 stages, my lord, the honorable courts answered in my favor. Finally, my lord, this honorable court held, no, it is enforceable, in spite of the award being passed by some other arbitrator. My lord, I take it with a pinch of salt. I have nothing to do with that. Now, my lord, I am saying, look, if it was passed by actual board of ARK Shipping, my lord, which is a Korean company, show me that Korean company's board resolution. That's all. Now, my lord, here somebody is ghost playing. This is what is our doubt. At paragraph number 19, my lord, I would also say, I state that the copy of the alleged foreign arbitral award relied upon by the present execution proceeding does not bear any seal of the arbitral tribunal. My lord, all these things. If it is ARK Shipping International South Korea is actually contesting this dispute against me, please show me. My lord, they are not. my lord, from Korea. They say that we are somebody authorized in India. They say that somebody, my lord, I need to know that whether actual person, actual legal corporate entity is contesting this matter. That's the reason I requested the Honorable Court, please call for a board resolution. Now, my lord, there are two things. If the learned judge has said, now it is a curable defect, please produce a board resolution. My lord, that would have ended my game. My lord, I have nothing more. I have to pay up. My lord, that is the reason I said, please look into this, call for a board resolution. Alternatively, the court could have said, now please, I am giving them an opportunity. If it is a curable defect, please produce the board resolution. My lord, they don't want to do that. They want to ghost play, continue that. My lord, even we don't know if it's actually ARK Shipping Korea is prosecuting this matter. I have, my lord, information which I can't put it on the papers, would say ARK Shipping, my lord, Korea is not interested in, my lord, continuing this 20 years long dispute. Lord, there is somebody else playing on their behalf. My lord, this is a bought over claim. This is a bought over claim. There are, my lord, entities in Bombay who buy over, my lord, this kind of claims. They're called as contingent, my lord, purchases. That, oh, you have something to get from here. Now I'll buy it over at a discounted price. My lord, this is something like that.
Lords, I
If
strongly
one
object
second,
for
sir,
this.
please.
It's a hearsay allegation, my lords, not a document,
My
not a
learned friend, my
single
lord, should
government
have some
is
patience.
placed in the objections.
Want
my
your
lord.
matter to be heard today. Let him continue. I'll hear you. Please understand. Yes.
Kindly, my lord, see my application. Your lordship sees my application. We said, page number 201. Dismiss, my lord, I kindly, my lord, appreciate my fairness. My lord, this is what I said. For the reasons stated in the accompanying affidavit, this honorable court be pleased to hold that the execution case number so and so is not maintainable for non-compliance of 3 Rule 2 and dismiss the execution petition as void ab initio, and in the alternative direct the respondent to produce within a time period a duly apostilled authenticated board resolution. My lord, can somebody be more fair than this? All the time saying is, don't, my lord, if my lord they produce a board resolution, my lord, would I still remain in the box? I'll go out. There is nothing more, my lord. Now 47, I have already taken one attempt. I can't, my lord, file one more 47. Your lordships may kindly, my lord, freeze my fate. I will not file one more 47 application, try to oppose the execution
What are
proceedings.
the judgments you're relying on?
Now, your lordship, see, my lord, how the court, the judgments I am relying upon. Kindly, my lord, have this in court copy. Na? Your lordships may kindly have Nidhan copy. Na? My lord, State Bank of Travancore versus Kingston. Very short portions, my lord, I am going to read.
Paragraph.
My lord, your lordships, kindly go to page number 5, paragraph 12. My lord, this is Honorable Supreme Court. The trial court then referred to the judgments of hope your lordships are on that, my lord, paragraph 12. The trial court then referred to the judgments of Delhi High Court in Nibro and so, and proceeded to observe that, as already stated, it has not been averred in the plaint nor sought to be proved that any resolution had been passed by the board of directors of the plaintiff company authorizing so to verify and institute the suit, as has also not been averred in the memorandum of articles of the plaintiff company that give any right to see so, verify, etc., etc. My lord, I skip that. Kindly go to my lord. May I just request your lordships to, my lord, come to paragraph 13. The division bench of High Court did take cognizance of the fact that the company had not summoned any witness from the office of the registrar of companies to prove that she so was a director of the company, and the minute book of the company had not been produced so as the director, but reversed the finding of the trial court issue number 1 on the basis of authority letter issued by and resolutions dated so by which the board of directors had authorized some persons to operate the bank account. In our view, the judgment under challenge is liable to be set aside because the respondent had not produced any evidence to prove that she was appointed as a director of the company, and a resolution was passed by the board of the directors of the company to file a suit. My lord, then Nibro, my lord, which was relied upon by the honorable, which was in fact appreciated by the honorable Supreme Court. Kindly, my lord, have the next judgment is Nibro.
Para.
My lord, paragraph, your lordships could kindly have, my lord, ink page number 14. Ink page number 14. My lord, the pagination is in the bottom, that is at page number 398. The court, my lord, extracted, ink page number 14, the second paragraph. The court extracted, it will be useful to reproduce through 2 provisions of the Civil Procedure Code, Order 3 Rule 1 and 29 Rule 1. My lord, I skipped that. It is, my lord, extraction of the legal provision. Then, my lord, should kindly go to ink page 18, my lord. Ink page 18. In the second half of the page, my lord, it starts as, after that, in my view paragraph, it is well settled. It is well settled that under section 291 of the Companies Act, except, my lord, now it is under section 179 of the Companies Act, except where express provision is made that the powers of a company in respect of a particular matter ought to be exercised by the company in general meeting. In all other cases, the board of directors are entitled to exercise all its powers. Individual directors have such powers only as vested in them in the memorandum and articles. It is true that ordinarily the court will not unsuit a person on account of technicalities. However, the question of authority to institute a suit on behalf of the company is not a technical matter. This is exactly, my lord, opposite whatever my learned friends have pleaded. It has far-reaching effects. It often affects the policy of the finances of the company. Thus, unless a power to institute a suit is specifically conferred on a particular director, it has no authority to institute a suit. My lord, in the second page, my lord, it spills over. Page number 19. The plaintiff has not placed any record, any resolution passed by the company authorizing so and so. My lord, then the entire suit was, my lord, dismissed. And my lord, lastly, kindly, my lord, have page number 29. My lord, it's a Commonwealth judgment, a judgment of the Commonwealth Court, the Appeal Court of Appeal of Tanzania. My lord, this is the judgment which is being borrowed by several, my lord, courts across the globe. Kindly, my lord, go to, well, it's persuasive value, but my lord, the question of law is, my lord, well attended to under this judgment. Kindly, my lord, go to page number 39. In the page number 39, the last paragraph, we now proceed to deal with main appeal beginning with 4th and 5th grounds of the complaint earlier paraphrased. The High Court is faulted in entertaining the suit on behalf of the respondent company without its authority by way of Board of Directors resolution and holding that the involvement in fraudulent transaction is respondent to warranted the suit to be filed without a Board of Directors resolution. Then your lordships may kindly turn over without a resolution. Mr. So-and-so submitted that this is to be irregular, adding that as the respective plaint was neither signed nor verified by the respondent, it is an indication that the company did not give any authority to institute on its behalf any case against the appellant. Then my lords may kindly come to page number, my lord, 44, ink page number 44, internal page number 16, the pagination, my lord, is in the bottom. My lord, on page number 44, in the middle, on the extreme right hand side, my lord, a paragraph would start as therefore. In the middle, my lord. Therefore, could the company, hope my lords got it. Therefore, could the company which according to the record before us had 5 directors to commence the suit without the authority of the company? We do not think so. On this, we borrow a leaf from the case of Bogerere Coffee Works, which dealt with an akin situation. In that case, an advocate instituted a suit in the name of the company, challenging the appointment of new directors following the removal of directors. As the court found that there was no evidence adduced to prove the authority of the company to institute a suit, it held the suit defective. In particular states, it particularly states, when companies authorize the commencement of legal proceedings, a resolution have to be passed either at a company's board of directors and meeting and record in the meeting. No such resolution had been passed authorizing these proceedings. Now, the next page, my lord, after extracting the entire earlier judgment in Bogerere Coffee, at page number 46, my lord, right after the italicized, my lord, letters, we subscribe to the said position to the extent that it relates to the institution of a suit by one or more directors in the name of the company that is held to be in. Lord, our Supreme Court, in unambiguous word says, board resolution is a must. All that we are saying is who is conducting this resolution execution proceedings? Is ours shipping or somebody else? If it is ours shipping, please produce that board resolution. Now, my lord, I undertake, my lord, my submissions may kindly be recorded that I will not file one more application to derail the execution proceeding. The learned judge, my lord, should have given some findings on this valid question. And I also said, please see, my lord, page number 211. Now, my lord, the award which is sought to be executed is not even signed, is not even, my lord, authenticated, which is, my lord, a bare minimal requirement under law. My lord, all these things we have said, we have lost. Now, I'm not going to once again relook into that. Is there a board resolution? All that. Kindly see, my lord, lastly, my lord, I'll take last 1 minute. Please see, my lord, how the learned judge deals with it. They argued, said it is procedural, not required. My lord, we said it's highly needed. Kindly see, my lord, page number 21.
Yes.
How the learned judge, my lord, approaches. The learned judge would not even say something which they said, would not even say something which I argued. My lord, the learned judge would give, in fact, my lord, at the initial, when we came before this honorable court, our humble complaint, my lord, I wouldn't call it a complaint, our humble grievance was that this order did not exist. It was only a docket order. Later, my lord, this order has come and I'm fine. I'm not going to carry any more, my lord, such grievances against the honorable court. Rightly or wrongly, there is some order. Now, does it order, my lord, attend to what we pleaded under 47 application? Please see, my lord, page number 21. My lord, after page number, and on page number 21, internal page number 17 of the order, after 4 lines. But herein in this case, the present application has to attract any ingredients of law enumerated under Order 21, Rule 29 of CPC. No single word is uttered by the judgment debtor in his application. My application is as vivid as I just read. I clearly say board resolution is not there, or please ask them to produce, or please hold that it is bad. Then further, the present application is taken up as per section 47 of CPC to attract either of the ingredients enumerated under 47 of CPC, also not been uttered by the judgment. Whatever the learned judge says that it is not there, it is, my lord, there more than what is required and very vividly. My lord, is this not, my lord, quite contrary to what I have pleaded? When it is there, the learned judge would say it is not there. And the learned judge would simply say, borrowing my learned friends, my lord, that holistic argument 20 years. 20 years is not disputed. If this is something which I could dispute at the stage of execution proceedings by authority under law, because the law gives me, my lord, that opportunity. The learned judge, all that, my lord, could have simply said is, please deal with this. That's all, my lord. I would, my lord, close my submissions. Let the learned judge, my lord, be directed to, my lord, give a finding that how it is not required. My lord, I'll be more than satisfied. I am so grateful.
Take my lord's attention to 201 of the petition, that the IA that have sought. They asked for, the prayer is, the execution 151 is not maintainable for non-compliance or Order 3 Rule 2, and dismiss the execution petition as void ab initio. Milords, before going to the matter, Milords, I would like to read Order 3 Rule 2, Milords, the recognized agents. Milords. Subclause 2A, Milords, the persons holding power of attorney authorizing them to make and do such appearances, applications, and acts on behalf of such parties. Persons carrying on so and so, Milords. Now, therefore, Milords, on the file of the court, there is an authorized power of attorney which is apostolated, Milords. It is also being executed before the Embassy of Seoul, India, Milords. That fact is undisputed fact, Milords. Neither they are questioning that, Milords. There is not a single averment that how a prejudice is caused, what is the prejudice that is caused on the authorization part, Milords. They have not questioned, not a single averment in the entire pleadings, Milords. Not a single reason what they have stated in their pleadings with respect to delay, Milords. Both they have kept silent, Milords. Kindly look at the timing of this application, Milords. Firstly, as I will not trouble my lords with the facts to be reiterated, Milords, I'll only tell the gist, Milords. 2005, there's a power of attorney, Milords, according to which an execution petition is initiated. Then the IA number 5 is filed, challenging the enforceability of the foreign award. Then that got dismissed.
All that not required. No,
Milords, no, Milords. The reason why I'm stressing on this point is the very authorized person participated in the previous two.
That's what I asked him.
They have not taken any contention with respect to that, Milords. Kindly permit me to submit this memo, Milords, with respect to the power of attorney which is there in the file of the court, Milords. And also the previous decisions, Milords, of the same matter. Page 54 of the memo, Milords. That's the power of attorney, Milords. 55, 56, and 57, Milords. In page 57, Milords, we can see the seal of Embassy of India. Duly stamped, my lords, and recognized. Not a single averment they have placed. How they allege that there is no proper authorization. Mere pleading, my lords, only hearsay. There's no other averment. Even in the additional grounds, my lords, that they don't divulge into the facts how this authorization is bad in law. Not a single averment.
Yes.
And with respect to a citation, my lords, we would rely on Bank of India and was this Naresh Kumar? Not that. Page 3, my lords. Identical matter, my lords. Here, the Supreme Court says, 18th line from the above, my lords. The procedural defects which do not go to the root of the matter should not be permitted to defeat the just cause. There is sufficient power in the courts under the CPC to ensure injustice is not done by any party to the just case. As far as possible, a substantive right should not be allowed to defeat the account of procedural irregularity, which is curable. My lords. Secondly, my lords, 17th line from the bottom, my lords, a person may be expressly authorized to sign the pleadings on behalf of the company. For example, by the board power of a board of directors passing a resolution.
This is in my favor.
No, my lords.
Passing a resolution.
To that effect, or there is or, my lords, or by power of attorney executed in the favor of the individual. My lords, in this case, there's a power of attorney, my lords. Therefore, the board resolution is an internal document, my lords, giving the authorization. Now, the petitioner and the JDR has to come before the court. If at all they allege there is some wrongdoing in the entire authorization, prima facie a document to say that there is any alleged fraud or misappropriation, whatever it is there. Nothing as such sort has been pleaded.
Yes. Order, sir.
My lords, and also, my lords, I would rely on two judgments. Rahul Shah, petitioner is already relied on that judgment, my lords. 6 months to be disposed of the entire execution, my lords. That may be considered, my lords.
Take the judgment.
My lords are averse to passing such orders. Your lordships, my lord, would
Because this is 21 years, it's a
Generally, my lord,
classic
not-
milestone
No,
case.
I'll be very much happy to pass order in this case.
My lords, a convenient synopsis is made, my lords.
We need 230 matters for that. What done?
My lords,
Lord,
a written synopsis is made for convenience of the court, my lords. Can I file?
Lord, serial number 142. Should it be kindly be taken upon 21st, my lord?
In list number 2, my lord.
My lord.
Lord, interim order,
My lord.
ಸಾಹೇಬ್ರೆ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗತ್ತಲ್ಲ 87 87
ಸೀರಿಯಲ್ ನಂಬರ್ 133 ಕಾಲ್ ಔಟ್ ಆಗಿದೆ ಬಟ್ ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಬೇಕು ಅಲ್ಲ ಅದು ಕಾಲ್ ಔಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ 133
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 87 ನೋಡಿ ಸರ್ ನೋಟ್ ಮಾಡ್ಕೊ ಸಾಹೇಬ್ರೆ ಜಜ್ಮೆಂಟ್ ರೈಟ್ ಸಾಹೇಬ್ರೆ 87 ಸಾಹೇಬ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಇದೆ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ 97
ಹಾ ಕೇಳ್ತಾರೆ
97 ಮೇಡಮ್ 97
97 ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ನಾಳೆ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ನಾಳೆ ಬೇಡ ಅನ್ನೋರು ಯಾರು ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ ಇವ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 109 ಇಂದ
Petitioner ನಾವು ಇದರಲ್ಲಿ 103 103 24 25 ಕೊಡಿ ಮೇಡಮ್ 25 103 103 ಮಂಡೇ ಕೊಟ್ಬಿಡಿ ಮಂಡೇ
ಒಂದ್ ನಿಮಿಷ ಇದ್ರೆ
ನಾಳೆ ಕಳ್ಸ್ಕೊಡ
103 ಮಂಡೇಗ
ಮಂಡೇಗೆ
ಇಲ್ಲ ಇದ್ರೆ ಮಂಡೇಗ್ ಜಾಸ್ತಿ ಇದೆ
ಟ್ಯೂಸ್ಡೇ
ನೀವು ನಾಳೆ ರಿಪೀಟ್ ಬೇಡ ಅಂದ್ರೆ ಅದು ಡೇಟ್
ನಾಳೆ ಬೇಡ ಹಾಗಾಗಿ ನಾಳೆ ಬೇಡ
103 ಮೇಡಮ್ 87 ಅದು 27ಕ್ಕೆ ಹೋಗುತ್ತೆ
ಆಯ್ತು
27 8
ಆಯ್ತು ಓಕೆ
List 1, serial number 138.
ಬೇಡ ಅನ್ನೋದು ಮಾತ್ರ ಯಾವುದು
ನಾಳೆ ಆಗುತ್ತೆ ಕೇಳೋದು ಅವ್ರ ಆಮೇಲೆ ಕೇಳಿದ್ರು ಅಂತ ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಅದರ್ ಸೈಡ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದಾರಲ್ಲ ಅದೆಲ್ಲ ಮೂವ್ ಮಾಡಿ ತಗೊಂಡಿರೋ ಮ್ಯಾಟರ್ಸ್ ಇವ್ರೆ ರಿಪೀಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್ ಈ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ರಿಪೀಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ನಾಳೆಗೆ
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮೇಡಮ್
ಡೇಟ್ ಇನ್ ದ ಲಿಸ್ಟ್ ಅಂತ
ಮೇಡಮ್ 150 serial number 150
ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಇಂಟ್ರಿ ಮಾಡ್ರು ಪೆಂಡೆನ್ಸಿ ಇರೋ ಮ್ಯಾಟರ್ ಮಾತ್ರ ಡೇಟ್ ಹೇಳಿದ್ರೆ
ಮೇಡಮ್
ಕರೆಕ್ಟ್
ಮೇಡಮ್
ಸರ್
serial number 150
ನೀವಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ ಅದರ್ ಸೈಡ್ ಮೂವ್ ಮಾಡ್ಕೊಂಡು ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅದು 87
ಮೇಡಮ್ serial number 150
ಅದನ್ನೇ ಮತ್ತೆ ನಿಮ್ಮ ಅದರ್ ಸೈಡ್ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಅದು ಡೇಟ್ ಆಗಿ ಬಂದಿರೋದು ಆಯ್ತು ನಾಳೆ ಬಂದಾಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಿಡಿ ಬೇಡ ಅಂತ
ಮೇಡಮ್ serial number 150 ರಿಲೀಸ್ ಆಗಿದೆ ಮೇಡಮ್
130 ಬಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಿಡಿ 87 ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ
ಮೇಡಮ್ 150 ಮೇಡಮ್ serial number 150
ಸರ್ ನಾನು ಹೇಳಿದ್ನಲ್ಲ ನೀವು ಹೇಳ್ದಂಗೆಲ್ಲ ಆಗೋದಿಲ್ಲ ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆ ನಮ್ಗೆ ನಾವು ವಿ ಹ್ಯಾವ್ ಟು ಲುಕ್ ಇನ್ ಟು ಇಟ್ ಅದು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಪೆಟಿಷನರ್ ಇದಾರೆ ಪೆಟಿಷನರ್ಗೆ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ನೀವು ಬೇಡ ನೀವು ಅದರ್ ಸೈಡ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ನೀವು ಇಬ್ಬರನ್ನು ಕರ್ಕೊಂಬನ್ನಿ ನೀವು ಆ ತರ ಡೇಟ್ ತಗೋಬೇಕು ಎರಡೂ ಸೈಡ್ ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿರೋರು ಯು ಹ್ಯಾವ್ ಟು ಬ್ರಿಂಗ್ ಅದರ್ ಸೈಡ್ ಅಂದ್ರೆ ಡೇಟ್ ಎಲ್ಲ ರಿಪೀಟ್ ಆಗುತ್ತೆ
ಮೇಡಮ್ serial number 150
ನಿಮ್ದು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರು ಮೇಡಮ್ ನೀವು ಮೆಮೊ ಮಾಡಿದ್ರಿ ಅಲ್ವಾ ಒಂದ್ ನಿಮಿಷ ನಿಮ್ದು
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮೇಡಮ್
31 ನೋಡಿ serial number 150 ರಿಲೀಸ್ ಆಗಿದೆಯಾ
number 2 serial number 47
ಅದಕ್ಕೆ ನೀವು ಮೆಮೊ ಕೊಟ್ಟಿದ್ರಾ ಜೇಪಲ್ಗೆ
44 ಅನ್ನು ನೋಡಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 138 ಯಾವ ಡೇಟಿಗೆ ಹೋಗಿದೆ
ಅದು ಹೋಗಿದೆ ಡೇಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್ ಇದು ಕರೆದು
ನಾಳೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಮ್ಯಾಮ್ ಟಾಪ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
serial number 150 ಮೇಡಮ್
138
ನಾಳೆ ರಿಲೀಸ್ ಆಗಿದೆಯಾ
138
ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 14% ಡೇಟ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ ಅದು
ಓಕೆ ಮ್ಯಾಮ್ ಥ್ಯಾಂಕ್ ಯು
serial number 150
number 47 ಮೆಮೊ ಕೊಟ್ಟಿದ್ವಿ
ಮೇಡಮ್ serial number 150
ಇವ್ರ ಮೆಮೊ 4 ಸರ್ ಇವ್ರ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು ಬರ್ಲಿಲ್ಲ ಚೇಂಬರ್ ಇಂದ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡಿ
ನಾಳೆ
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮೇಡಮ್ 44
serial number 150 ಮೇಡಮ್
list number 2 serial number 47
ಮೇಡಮ್ 150
list number 2 serial number 25 madam list number 2 serial number 47
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 150 ಮೇಡಮ್
44
ಸರ್ ಅದೆಲ್ಲ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಆಲ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಮ್ಯಾಟರ್ಸ್ ರಿಮೈನಿಂಗ್ ಏನಿದೆ ಎಲ್ಲ ರಿಪೀಟ್ ಆಗುತ್ತೆ
ಯಾವತ್ತು ರಿಪೀಟ್ ಆಗುತ್ತೆ ಮೇಡಮ್ ಅದು ಮೇಡಮ್
ನಾಳೆಗೆ ಸರಿ
ಓಕೆ list number 2 serial number 47
ತಂದು ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ ಅದು ರವಿ ಕೈಲಿ ಕೊಡಿ
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮೇಡಮ್ ನೋಡಿ ಅದು 44 ಸೀರಿಯಲ್ ನಂಬರ್
list number 2 date number 47
ಸರ್ ನಾವು ಡೇಟ್ ಕೊಡ್ತೀನಿ ಸ್ಟಾರ್ಟ್ ಡೇಟ್ ಎಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ ಹೇಳ್ತೀನಿ ನೋಡಿ ಎಲ್ಲ 60 ಮ್ಯಾಟರ್ ಅಪ್ ಟು 31st ಆಗಸ್ಟ್ ನೋ ಡೇಟ್ ನೋಡ್ತೀನಿ ನಾನು ಅದು
ಅಪ್ ಟು 30%
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 serial number 47 ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 serial number 47
ನಾಳೆ ರಿಪೀಟ್ ಅಂತ
ಸರಿ
ಎಷ್ಟು ಸತಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಮಾಡಬೇಡಿ ಸರ್ ನಮ್ಗೆ ಸುಮ್ಮನೆ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ
ಕೇಳಿ ನಾ ಹೇಳ್ತಾ ಇದ್ರೆ ನಾಳೆ ಹೇಳಂತ
115 ಮೇಡಮ್
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ರಿಪೀಟ್ ಆಗುತ್ತಮ್ಮ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ 31 ನೋಡಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2
31 ಇರೋದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಡೇಟ್ ಹೋಗುತ್ತೆ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಸಬ್ಮಿಷನ್ಸ್
Court officer, serial number 116. ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 116 ಹೇಳ್ಬೋದಾ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅಥವಾ ಏನಂತ? Let him also go. Sir, 116 next date ಯಾವಾಗ ಸರ್? Cost list on serial number 116.
ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ.
Serial number 116 madam.
ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್.
Order.
ಆರ್ಡರ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಕಾಲ್ ಔಟ್ ಆಗಿದೆ, ಸೆಪ್ಟೆಂಬರ್ಗೆ ಹೋಗಿದೆ.